456 days locked in a psychiatric facility for pleading the fifth.
You're always polite, but basically you won't talk to me. And you won't talk to your lawyer. You've been in jail for 455 days or whatever I calculate, 456 days, or at the forensic center. If we could get you to cooperate and open up, this matter could probably be resolved and you could get released. But at this point, we're stuck in this closed loop of you not wishing to talk to anybody or assist in your defense. Are you willing? Is there anything you want to say to me here?
And there ain't nothing to talk about, man. I still plead the fifth.
The Fifth Amendment protects you from self-incrimination. But for one man, James Jude, exercising that right has resulted in him being held in a psychiatric facility for 456 days and counting. This is the story of how a defendant's refusal to speak has trapped him in a legal paradox with no clear end in sight.
Good afternoon, sir. Are you Mike Jude?
Yes.
All right, could I ask you to take your hat off?
Sorry, I'm a solid road. I just get off work.
All right, you're fine. We're about to bring James in here.
Okay.
He's at the forensic center, and his MO has been not really very cooperative. He's not belligerent. He just doesn't really want much to do with any of this. So we'll see how this goes. So I'm going to bring him in and call the case.
Okay.
All right. Good afternoon, Mr. Jude. This is Judge Middleton. I'm here at the courthouse in Centerville. Also present is your lawyer, Rhonda Ives, and prosecuting attorney, Angela McCamfield. Your brother, Mike Jude, has also joined us here for this hearing. To recap, Mr. Jude was charged in May of 2024 for the home invasion, third degree, and malicious destruction of property over 200 but less than 1,000. Malicious destruction of property over $200 is a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. The home invasion charge is a felony, and it is punishable by up to 5 years imprisonment. Defendant was arraigned on those charges, and he's been in custody now for more than a year. Between jail and the forensic center, as of May 24th, he was in jail for 365 days. May 15th, he was in jail for 365 days. So add 16 days in May, 30 days in June, 31 days in July, and 14 days. That's 30, 91 days, 365 plus 91. You've been in jail for 456 days or at the forensic center. We received, our last hearing was in May, and we had received a letter from the Center for Forensic Psychiatry that they believe that you're still incompetent, but that you are restorable to competence. Most of the issue here, as I've seen it, Mr. Jude, is you just won't talk to anybody. You didn't really want to talk to me. You didn't want to talk to your lawyer. You didn't want to talk to the people at the forensic center. You just wish we would all go away, but we're all stuck here. I have received a most recent report, date stamped August 12th, from the Center for Forensic Psychiatry. It's by Graham Parker, limited clinical social worker, certified forensic examiner. Ms. Camfield, on behalf of the prosecution, may we consider that report for this hearing?
Yes, I would allow that, Your Honor.
Ms. Ives, you concur?
I concur, Your Honor.
As the judge reads that report, it's worth asking how this is possible. The defendant is trapped in a bureaucratic nightmare. The court says he can't go to trial until he's proven competent, but the only way to prove he's competent is to give up the very right he's trying to exercise. It's a system that's seemingly designed to keep him locked up.
All right, I'll get right to the bottom line and then I'll quote further from the report. The conclusion of Dr. Parker, or clinical social worker Parker, he's not a doctor. It is my opinion that Mr. Jude remains incompetent to stand trial at this time. It is believed with continued treatment, he will be likely to meet the statutory criteria for competency to stand trial prior to the expiration of the treatment order. And I believe the treatment order is good. I was trying to look at it. I think it's 15 months. So at some point, if we don't get where we're going, we're going to have to pursue a different cause of action. Back in July of 25, a previous doctor, Dr. Journey, Jouney, Jouney, stated, since his admission, Mr. Jude has been unwilling to speak with members of his treatment team. When I asked him to meet with me, he entered the interview room, refused to sit, and asked, and then left without answering any questions. His social worker, the chief clinician, reported similar encounters. They reported Mr. Jude's conduct as generally good. He's made friends. He's adhered to unit rules and been responsive to staff requests. He's not displayed any irritability, aggressiveness, or atypical behaviors. He's not been prescribed any medicine other than olanzapine, which has not been taken. And then here's their opinion. The concerns relating to Mr. Jude's previous competency evaluations continue to remain present. Mr. Jude appears to demonstrate the basic capacities to understand the nature and object of the proceedings against him. However, he has difficulty discussing and applying these concepts to his case. Mr. Jude has difficulty participating in a rational discussion relating to his legal matters. Overall, Mr. Jude's present mental condition continues to interfere with his inability to discuss his legal charges in a rational manner and ultimately assist with his defense. Mr. Jude would benefit from further restoration treatment within a structured setting to work toward obtaining competency. Mr. Jude, I've talked to you here in the courtroom, on Zoom from the jail in Centerville, and a couple of times from the forensic center. You're always polite, but basically you won't talk to me, and you won't talk to your lawyer. You've been in jail for 455 days, or whatever I calculate, 456 days, or at the forensic center. If we could get you to cooperate and open up, this matter could probably be resolved and you could get released. But at this point, we're stuck in this closed loop of you not wishing to talk to anybody or assist in your defense. Are you willing? Is there anything you want to say to me here?
And there ain't nothing to talk about, man. I still plead the fifth.
All right.
I know my rights, man. It shouldn't even go this far.
All right. Now, as a rule, well, the Fifth Amendment says that the defendant's statements cannot be used against him if they're taken in an involuntary manner. Your statements to the doctors are exempt from use in any criminal proceeding against you. Your discussions with your lawyer are privileged. Anything you say to your lawyer cannot be used against you. There's an absolute attorney-client privilege that protects that relationship. So at some point, you're gonna have to talk to somebody, or we're gonna be here for a long time. What the
Ain't nothing to
actual
talk about,
allegation
so.
was, is that you,
What you want me to do?
but,
Just have a conversation with them about whatever?
well, not even necessarily
You wanna
about
talk
what
about
happened.
sports? What?
Yeah,
Ain't nothing to talk about.
talk about your ability to assist with your trial. Understand the charges against you, be willing to cooperate with your lawyer, be willing to answer her questions. You don't have to tell me a thing, Mr. Jude. You're right. You have a Fifth Amendment right not to testify or disclose anything if you don't wish to. I can't call you to the witness stand and put you under oath and say, hey, tell me what happened.
I've already
This
talked
is
to
what-
Rhonda too. I told her what she needs to know. Like I said, what else you wanna talk about?
She wants to talk about whether the prosecutors offered a plea agreement, whether you would accept the terms of the plea agreement,
I ain't
whether
taking no
you've
plea,
been,
man.
all right, or
Said
whether
this
we're gonna
shit
have a
like
jury
5
trial.
times.
Right now, the case is still in district court. The charge is a felony. We haven't even gotten past the preliminary examination stage. Now, your brother Mike is here. He's concerned about you, and he's been in contact with the court. They may pursue a involuntary commitment, but at some point, the clock is ticking. I encourage prosecution and defense to take a look at the mental health code, because we can't kick this can down the road forever. I think it's
Yeah, it's a
15
joke,
months.
man. It shouldn't even gone on this long.
Yeah, that's regrettable, but it's not like part of it isn't your fault. I'd like to have this case over with a year ago.
Yeah, you could.
So, yes, well, I make a finding that I adopt the opinion of the forensic examiner. I find that the defendant is incompetent at the time, but restorable. He shall remain under the supervision of the Michigan Department of Health and Human Services. He is presently at the Center for Forensic Psychiatry. As a condition, no, you're not released, but James, I think we can get this case resolved. Either by plea or trial, but we got to get past this hurdle. I believe this is the last time we can do this. Anything further would have to be a petition for involuntary hospitalization. And Mike is aware of that. But we need to, and I've looked at it, you guys need to look at the statute regarding competency and continued commitments. Mr. Jude, my advice is try to cooperate with the people and cooperate with your lawyer, and let's see if we can get past the competency hurdle to either get the matter resolved in district court.
I have been, man.
All right, sir. I wish you luck. I'll be seeing you probably within the next 90 days.
Yeah, I'm sure.
Oops.
We done.
All right, you're good to go. All right, Mr. Jude, they're going to hold on to him for a while longer, but at some point, if he's found not to be restorable to competence, there has to be a petition for involuntary hospitalization. We've got people that have never been competent again, and there's one man, he's been at the forensic center for 35 years, and once a year they have a competency review. I don't want that for James. It's a kind of case where he probably would get time served if we could ever get the case to the finish line. All right. Thank you for being here.
And so he's sent back to the facility, trapped in a legal paradox. But what do you think is the right way to handle this? Is the system wrong for keeping a man in custody for his silence? Or is the defendant taking his rights too far by refusing to even have a confidential talk with his own lawyer and doctors?